Again, you guys, grown to a very strong firm. I mean, you started strong, but you're really strong. As you look back, is there anything that sort of has surprised you along the way on this journey you guys been on? I mean, you bet on yourself, gut feel, you did it. You had a vision. It sounds like you've achieved a good piece of it. I'm sure it was not a straight line. It never is. But any surprises along the way other than the 11th Circuit argument you had to do?
One surprise, I guess, from a business perspective, when we formed the firm, there was a lot of talk about the demise of the hourly rate. That was about, 12 years ago. There was articles about how a lot of firms were, doing alternative fee arrangements. And we began our firm with a similar mentality. We wanted to present alternatives to the hourly rate, and we have. I mean, we've incorporated those to some extent. But one thing that has surprised me is how sticky that has been, and that today, I think more than even 10 years ago, that is probably the most common fee structure that exists in major business litigation matters. That's a business surprise.
Welcome to the Founding Partner Podcast. Join your host, Jonathan Hawkins, as we explore the fascinating stories of successful law firm founders. We'll uncover their beginnings, triumph over challenges, and practice growth. Whether you aspire to launch your own firm, have an entrepreneurial spirit, or are just curious about the legal business, you're in the right place. Let's dive in.
Welcome to Founding Partner Podcast. I'm your host, Jonathan Hawkins. This is a podcast where I get to interview founding attorneys, learn about their journey and lessons they've learned along the way. And this is a very special episode. This is the 100th episode of Founding Partner Podcast. And it's very special because I have my two friends coming on. We got Mike Caplan and James Cobb. And it's also special because this is actually the second time we're having this podcast. We can talk about that too. The first attempt got lost. So I think this time, hopefully that doesn't happen. But I think being in person will also give this a different feel also. So Mike and James, thanks for coming on. Thanks for doing this again.
Thanks for having us. We're excited to be here, and I'm glad that first one got lost because we had an excuse to be together in this fancy studio and be celebrating your 100th episode.
Amen. Also, the first episode was terrible, so we get a chance to redo it.
There you go. Yeah. So I'll do a quick intro of you guys, and then you guys can sort of explain your firm. I'll give it from my perspective. I've known you guys for a long time, since before you started your firm, and you're coming up on your 12th year anniversary. And for people who are not from Atlanta, you guys have built what I think is one of the preeminent sort of business litigation boutiques in Atlanta and in Georgia. And you guys both have good pedigrees, came out of good boutique firms to form this and create your own. And I think your timing was really good. I remember back in the day, probably your colleagues thought you were crazy because you were leaving really good firms. They're like, what the hell are you guys doing? But with hindsight, you guys have really built something special. And I remember when you started, and I remember when you hired your first attorney, and now you're up to how many?
18.
18.
That's right. As of later this month, I should
That's
say.
awesome. So why don't you sort of give an overview of what your firm does? I call it sort of business litigation, but I think you guys probably can describe it better than that.
Sure. Why don't you go ahead, Mike? I can jump in.
Sure. So we're a litigation firm that specializes primarily in business litigation or commercial litigation, appellate practice, and class actions. We consider ourselves generalists in the sense that, there are a wide variety of matters that we are capable of handling, but they typically involve high stakes business litigation or issues that involve, significant exposure or significant complexity. And we enjoy being in the courtroom, but we also enjoy trying to resolve matters that never see the light of a courtroom. So that tells you a little bit about our firm. I can go into more detail if you'd like.
And I would say, I'll kick it to James, but and you guys are going up against the biggest of the big firms. I mean, it's not like, you can probably give me the list, but I mean, we're talking big firms that you're going against. So this is substantial, significant dispute litigation that you're involved in, which is impressive. I mean, it really is. And I mean that sincerely. So I want to go back. I want to go all the way back. So I sort of alluded to it. You guys both were at very prestigious boutiques here in Atlanta, but you guys decided to leave to start your own firm. So I want to hear the story, but I imagine when you went to tell your firms, they probably thought you guys were crazy.
As did our families and most of everyone else.
So I guess the first question is what compelled you to do it? What was the spark? Why did you do it? And then maybe the second part, why did you two do it together? How did you guys come together?
It's a good question. I'm happy to take the first one. You can take the second one.
Sure.
So why did we do it? So I was immediately before this firm practicing at Rogers & Hardin, an incredible, really full-service boutique, but at the time, very, very strong litigation firm. Had practiced at a large firm in Boston called Ropes & Gray before that and had a great experience at both firms. I thought I would spend my entire career at Ropes & Gray at Rogers & Hardin after moving back to Atlanta. Was very happy there, worked with exceptional lawyers. I still feel today like essentially every good habit I have as a lawyer is due to what I learned under those guys, in particular Richard Sinkfield and Dan Laney and a host of others. And I never thought I'd leave. Had a bright career there, bright future, but I always had this itch to do something that was a little bit different, but I didn't think I thought I was too risk averse to do that. And Mike can tell the story of how we got to know each other and how we kind of danced around this idea for some time. But there came a point where the path was clear. It was either spend the rest of my career at Rogers & Hardin and build a practice there, or try to do something that's new and have a little bit of more control over my destiny. And for a lot of reasons, I want to hear what Mike says before I tell you what my reasons were, but this felt like the right move, despite the fact that if you looked at everything on paper and you did a pro-con list, there was a lot going for staying with Rogers & Hardin. I have incredible affection for that firm and for the lawyers that I practice with there. But this felt like the right thing to do. In the end, it was a gut feeling. And I'm incredibly glad I did it because it's been the best professional decision I've ever made.
Gut instinct is a great way to put it. I think that probably best defines, my own decision. I had a similar story to James. I was at a firm called Bondurant Mixon in Elmore, which is a great firm, still around, and a firm that we actually do quite a lot of work with these days, are often against now. I worked with lawyers there who were my great mentors, like Emmett Bondurant, Jeff Bramlett, Frank Lowry, and others, and also expected to spend my career at that firm. James and I really interacted the most as opposing counsel in a securities case where we were both the kind of lead associates, or perhaps among the lead associates on the case, and we ultimately got to know each other pretty well in that capacity as opposing counsel. It was a pretty contentious case where, there was a lot of discovery fights and there was some acrimony, but James and I were always able to communicate very well diplomatically. We kind of enjoyed, I think, the dialogue that we had, even when it was, challenging because of the dynamics of the case. So that's how we really got to know each other. Although it turns out, as we figured out later, that James and I first met as effectively opponents in a moot court competition. We were both participants for our moot court teams. James was at George Washington, I was at UGA, and we both landed in the finals of the ABA moot court competition. And we found, we realized later that we were in that same competition together. But through our opposing counsel relationship, we got to know one another. Ultimately, that case settled, and I believe I suggested lunch with James, and we had lunch, and almost spontaneously at the end of that lunch, I asked James, what was his goal in his career? Did he intend to stay at Rogers and Hardin, or did he have other ambitions? And part of me was very interested in opening a conversation with James about potentially starting a firm, but it was almost a spontaneous thing. It wasn't like I invited him out to lunch because that's what I intended to do. And that began what became about a year or so long wooing period, if you will, and deep conversation about what it might look like to start a firm together. And, I think the reason that we did it or the reason that I did it was similar. It was I faced this opportunity to begin a firm, to bet on myself, to control my own destiny with someone who I had immense respect for. And, I, almost instinctively, or from the observations that I made about James in terms of his character, his professionalism, his style of advocacy, the quality of his communication, the seriousness that he took his work, but also the humanity that he brought to his practice, being kind to his opposing counsel and able to deal with difficult situations in a, very professional and diplomatic way was just very impressive. And I had this innate confidence that forming a firm with him would work. And it did. And I don't think that I would have done this. I don't think I would have formed a firm if it was not for the opportunity to do it with James, because, like I said, I had full intention to, really stay at Bondurant and build my career there. But I also had this entrepreneurial spirit and this desire to sort of see what it would be like to build a firm from the beginning. And when the opportunity really presented to do that with James, I said, I'm all in.
So I got to know, who won the ABA moot court competition?
Well, neither of us.
we both lost to the same team.
Okay,
that's the funny part of the story.
That's good.
Yeah. We both lost to the same team.
We were both, we both made it to the semifinals and finals, and I won't say who made it to which, but we both lost to it was South Texas.
South Texas.
Do you know where those lawyers are now?
Excellent.
Yes. Yeah.
They must have been really excellent.
Yes.
You asked Jonathan.
They're both on the U.S. Supreme Court now, right? Yeah.
You asked if the lawyers at Rogers and Hardin and Bondurant thought we were crazy when doing this, and all I'll say is I have vivid memories of talking to people about this decision, and universally, and I think Mike would say the same thing about his experience, but universally it was a combination of, we're very disappointed, but we wish you the absolute best, and we'll do whatever we can to help you succeed. And I think that was that was a kind of both Mike and I had the confidence to do this, but it was also a nerve-wracking thing. I mean, we had young kids. I had a fourth child on the way at the time, and that was a wonderful response to get from a group of lawyers that you have a lot of respect for. Yeah.
So I want to talk more about the timing. So you said you guys were basically wooing each other or whatever for about a year. The timing is never seems to be perfect. So, after, at some point it happened. So what made it happen? And how did that sort of go down? Because you're at two different firms, did the timing for both of you line up perfectly, or how did that go down?
It was probably a 3-year wooing period, I think.
Was it that long?
Yeah, it was a long time, because there were moments where I was actually thinking about this talking about this the other day with Gretchen, my wife. There were moments where it was right for you and not right for me. There were moments where it was right for me and not right for you. And then there was a moment where it was right for both of us. And I don't.
It was also the Christmas dinner we should talk about.
Yeah. But I don't want to go too much into the details about what was happening with my experience at Rogers and Hardin, other to say it was incredibly positive. And I was presented with an opportunity that really forced me to decide what direction do I want my career to go in. And that coincided with where Mike was and helped me make the decision that, okay, now's the time. If I'm going to do this, this is the time to do it, not 10 years from now, which I think would have been the alternative, which would be about where I am today in my career. But I wonder what your response to that is.
Well, yeah, we spent a good bit of time. The beginning of the wooing period was, hey, let's talk about what a firm might look like. And I think, we, over the course of a few months, we exchanged, like an outline of what areas of practice we might focus on. We talked about, what our model might be. We talked about, would we focus on hourly fees, or would we think about contingency fees? Would we be a defense-only practice, or would we combine, plaintiffs and defense work? And those conversations were a key part of building the confidence and the excitement, because, we were sharing a vision, but also, allowing each other to kind of, openly test what a strategy would be and what the firm might look like if things went well. But the conversation, we didn't write any checks. We didn't, sign any documents. We were really just talking. And that lasted for quite a while. I don't know that it was fully 3 years, because I feel
Probably
like
2.
it was probably closer to 2.
Yeah.
But then came a Christmas dinner where, we had at this point said to one another, we were convinced that we should do it. But, there were opportunities at our firms that we really, and responsibilities at our firms that we were very serious about. I mean, James had trials, coming up. And, I remember I was working with Emmett Bondurant and Frank Lowry on a big case that ultimately went to the U.S. Supreme Court. And, so we didn't want to miss out on these opportunities that we had, and also not fulfill the responsibilities that we had as, being part of teams at these firms. But on the other hand, increasingly grew serious. Well, after a few glasses of wine and a really nice Christmas dinner at James's house, I think it was my wife, Anna, who sort of turned to us all and said, like, are we doing this or not? And she basically said, if we're going to do this, then y'all need to break out a checkbook and write a check. And I think it was within, a few days of that dinner that we decided to, form a bank account, or, write a check, commit a certain amount of capital to, begin working on website and logo and things of that sort. And that's what really, I think, took us over the hump. And then, of course, if you want, I can sort of broadly tell a story of how we ended up starting the firm a bit earlier than we expected.
Yeah, let's hear it.
Yeah, so, I mean, obviously duty to client comes first, and there was I had a client relationship where, we were sort of restructuring, not just me, but other lawyers at the firm that I was with were in discussions with a client about expanding our relationship. And those discussions ultimately led to me feeling like if I might need to tell the client that I have an intention to leave the firm and form my own firm. But of course, you typically don't want to do that with a client before you tell the partners at your firm or the folks that you're working with. And so I had something of an ethical quandary, and I met James for dinner after getting some legal advice and deciding, look, we're at a place where if we're doing this, I now have a duty to tell my firm that I plan to do this, my colleagues at Bondurant, so that I can also tell the client. And so I met James for a glass of bourbon at Twain's in Decatur, and said, James, if we're doing this, we're, we got to commit to doing it right now, because I think I need to go in tomorrow and make the disclosure that this is our intention. And I told James that, I think he had some things coming up, and we had not intended to start the firm this quickly. I think we intended to start a few months later. And James, being the incredible human being and partner that he has always been and is, said, well, if you're going in tomorrow and telling your firm, I'm doing the same thing. And that's what we did.
Yeah. That was, I had a trial coming up in a case that I wanted to see through. And so I think we were planning to start the firm in like May of 2014, but this was in February of 2014. And I remember you being kind of amazed that I said, well, yeah, I'll go. You're not doing this alone. And as I've thought about that over the years, it's the kind of thing that I would expect of you, right? That I know you would do that. If the situation had been reversed, you would have said exactly the same thing without any hesitation. We had a lot of discussions in Mike's basement about what the firm would look like, right? And I mean, down to details like the name, Caplan Cobb. And there was this moment where both of us were advocating for the other to have their name first, right? Mike was like, no, it's got to be Cobb Caplan. And I was like, no, it's got to be Caplan Cobb. And we settled on Caplan Cobb because it sounds better to transition from a soft N to a hard C than transition from a hard B to a hard C. And I think it was the right decision. But there are these vignettes from that experience that have just confirmed partnering up with him was the right, because he is not an ego-first guy. And I'm not an ego-first guy. We're in this together. Our goal was to build a firm. If you look at the history of small firms all over the country, very few survive the retirement of their founding partners. I'm sure you thought about that with this podcast. And our goal, I remember having a discussion about this. We want to build a firm that outlasts our careers, right? And how do we do that? I don't know. I mean, we've tried to figure that out. We're in that process now. But that was the goal from the beginning, and I never had a doubt that this was the right guy to do it with.
So I do have a theory on that. There are exceptions. This is the rule. There's always exceptions. And, I encourage firms to try to figure out how to become the exception. But I think the max lifespan of a firm is 35 years or within 5 years of the last founding partner.
Is that the rule against perpetuity?
Hanging it up. Pretty close. But that's sort of my theory. And we've seen some of that in I won't name names, but
Sure.
in recent
Sure.
legal stories we've been hearing here in Atlanta seems to be sort of holding true. There are exceptions. I mean, their firms have been here, 150 years at this point now, so there are definitely ways to do it. But yeah, you got to work to do it. It doesn't happen by accident, for sure. So I want to talk more about your partnership and sort of the dynamic. Before we get to that, I want to go back to, you mentioned, James, at the time you had your fourth on the way, or maybe had arrived at this point. You were both at very, prestigious firms, probably making good money. That was probably, not easy to just walk away from. Like I said, the first thing you had to get your spouse on board, and it sounds like, Mike, your spouse is the one who actually forced it to happen. But the other
she was
thing,
just tired of hearing us talk about it. She was like, either y'all are going to do this or not.
Shut up. But so, a question a lot of people have is, when you start a firm, did you have cases or clients? Did you have work, or was it just a complete leap of faith? Or did you have what you believe to be a pipeline of potential work? So
it's a good question. And we planned for not having any clients. I'll let Mike talk about how that's not how it actually turned out. But the idea of our firm was really based on the small number of high-end complex litigation boutiques in Atlanta that were populated by lawyers who used to work at big firms, who have the credentials and the experience and the ability to handle very complex and significant cases, but that for any number of reasons prefer to operate in a smaller environment. And if you look around, we started our firm in 2014, you could count on one hand the number of litigation boutiques that had lawyers who clerked for federal judges, who had spent time at big law firms, and who had experience representing corporations in very significant disputes, either on the plaintiff or defense side. And so we saw an opportunity there, but also, Mike is really charismatic. I try to be charismatic, and we've built good relationships, and we thought our referral sources are going to be our best source of business. It turned out to be a little bit of both, and Mike can talk about that, but, we started getting phone calls maybe on, week one, and we hired our first associate within 6 weeks. He's now a partner at the firm. We hired our second associate within a few months. He's now a federal magistrate judge in the Southern District of Georgia. And that idea that there's an opportunity for a firm that has lawyers who, have the experience and credentials of the big law environment, but want to practice at a small one and handle kind of generalist type business cases has played out, really, really well. That's still our bread and butter in terms of our business. But we did end up having some cases on day one.
Yeah, unintentionally. So, the short answer to your question is, the people who thought we were crazy probably had a bit of a point, because we really didn't have clients when we started the firm. And although we had confidence in ourselves and a belief that we could get clients and get referrals from other lawyers primarily, we had not tested that belief. And, to be candid, I think maybe I had brought in a small matter at Bondurant at the time I formed the firm, but I had not originated many cases either as an associate. And part of the challenge of originating cases when you're a young lawyer is just title, right? And at that time I was an associate. But it did turn out that, in large measure due to what was I think, incredibly generous and professional approach that Bondurant took to my departure, which was similar to James, where folks were, obviously disappointed that I was leaving, but also, supportive. I mean, they handled it very professionally with clients, and they gave clients the option of letting me continue to work on their cases. And so even on day one, we didn't expect to have this opportunity, but we were able to work on some cases that I had currently been, at the time, was working on by essentially partnering with Bondurant. I think that's very unusual for that, to happen, and that's really a testament to, the lawyers at that firm putting their clients first. And then, as James said, within days of forming the firm, James and I had made a very strong effort to market ourselves when we left our firms and began our new firms. We, I think, got an article in the Daily Report. We, scheduled breakfasts and lunches with just about everybody we knew, and tried to keep our calendars extremely busy. And, from the relationships that we had built and the, desire of our friends and colleagues and, co-counsel and even opposing counsel, we were fortunate to begin getting referrals very, very early. I remember one of the big cases that I had been working on when I left was adverse to a lawyer in town named Bruce Brown, who's a good lawyer and a good friend. And just like James being my opposing counsel and a relationship that I built and, my now partner, Bruce was one of our first referral sources. He sent us a client. I think he had a conflict or something like that, and it became a pretty significant matter for us. And I was very grateful for his recommendation, and that, took a lot of confidence on his part to recommend to a client, a firm that had just started literally weeks before. So, we were fortunate to have the sort of a good spirit of others to help us begin our firm. And that really did happen in the beginning months.
Meant to be. Real quick, if you haven't gotten a copy yet, please check out my book, The Law Firm Life Cycle. It's written for law firm owners and those who plan to be owners. In the book, I discuss various issues that come up as a law firm progresses through the stages of its growth, from just before starting a firm to when it comes to an end. The Law Firm Life Cycle is available on Amazon. Now back to the show. So I want to circle back on sort of the partnership piece. I talked to a lot of folks that are going into partnership with people. I've had people that form a partnership and it's done within 12 months. They come together and it doesn't work. And you guys have been at it for almost 12 years now, maybe 14 if you count the 2 years to get there. And so as you sit here today and reflect back, for others out there that may be exploring a partnership, what advice would you give in terms of, how to explore it on the front end and then how to make it work after you've come together?
One of my closest professional advisors is my father-in-law, Charlie DeVetter, who's an accountant and started a firm on his own early in his career. And he was very supportive of going down this road with Mike. And Charlie framed it like this. He said, look, a small partnership is like a marriage in a lot of ways. On the financial side, everything financially about your partners, you've got to make decisions that impact your personal lives, at least the financial aspect of them. And you're taking on this obligation if you start hiring employees to support them. And that's going to fan out beyond just the people you hire. It may be supporting kids and spouses. And so you ask yourself the question when you're considering a small partnership, do you want to be married to this person in that, professional sense of the word? So that helped me frame this decision. And Mike and I spent a couple of years getting to know each other. And through that process, I came to view him as having strengths that are complementary to my weaknesses and weaknesses that are complementary to my strengths. And the combination of those two things, I think, has been the key to the success of our partnership. But I also feel like I was incredibly lucky to have my path cross with him. And you can't plan for that, right? You have to be opportunistic. When the opportunity presents itself, you have to be willing to do it. So that's luck, right? If I had never met Mike, we wouldn't have this firm or all these people who are now working with us. So I'm grateful for that. But I think finding someone with a shared vision with complementary strengths and weaknesses to me it would be key.
Yeah, I wholly agree with all that. Yeah, and I couldn't imagine doing this, having done it individually. To me, part and parcel to the decision to start the firm was, as James just articulated, the opportunity to do it with him and to, share in the decision making and build something together. And so, in terms of looking back and thinking about people who are maybe listening to this podcast and deciding whether to start a firm, I think that thinking through what your goals are is very important, because starting a firm is very hard. It's certainly, we can talk about all the exciting aspects of it, and we have been very fortunate in the success that we've had and the growth that we have achieved, which has been probably more than we expected. But, there have been, challenges. At the beginning, the first number of years were extremely challenging and required not only doing the work of a, business litigator day in and day out, but doing it with far less resources than we had become accustomed to, and having the, burden of marketing ourselves and our practice and trying to build a successful business. All of the logistics, mechanics of organizing a firm. I'll never forget the day when I had an 11th Circuit brief due. This was in the first couple months of our firm's, founding, and it was the day of filing, and, I had to go to Kinko's and do the binding and figure out what colors to use, because the 11th Circuit rules require a certain color paper for different briefs, and I thought back to my time at my last firm and said, boy, somebody else would be doing that. And that may be the only day where I thought to myself, did I do the right thing? Because we had not yet built, a paralegal or staff function at our firm. And so one of the things that I would say is, today is a little different because of we had a lot of digital resources, right? We had electronic research, we had computers, we basically were able to, keep our firm in our laptop. But, there are still a lot of aspects to operating a firm today that even with technology doesn't solve. And that is, your operations, your marketing, your, all the other things that go on beyond just being a good lawyer. And so what I would say is have a good plan for how you are going to handle the administrative and operational aspects, of your firm, and be wise and thoughtful about your use of time. Because, if we didn't have the time to go out and market ourselves and, be really intentional about the way we invested our time at the beginning, I don't think that we would have achieved the success that we have. And one of the important decisions we made early was hiring a, administrator. We made an important decision even when we perhaps didn't need or have enough work to hire a lawyer. We kind of continue to bet on ourselves early. And if you are going to make a bet on yourself, then you got to be willing to kind of go all in with it. And so, and that I think, reflecting on some of the decisions where and when James talks about, complementary skill sets, this is the example. My tendency is to be cautious about, well, should we, invest in this new, software, or is it really worth it? And James is like, well, you know what, we bet on ourselves to, start this firm, why don't we assume that we're going to achieve the goal that we have set out in 6 months, and if we are going to achieve that, then we probably need this resource, or we probably need to hire this person, and very thoughtfully considering the decision making, with the confidence that we can achieve the goals that we have set out, and that type of betting on yourself and that kind of direction in terms of growing your firm in a way that allows you to devote your time to the most important parts of how you grow your practice, which include marketing yourself, developing business, and then practicing law with your clients, I think is very important.
Before you move on, there's a fantastic story involving the 11th Circuit that I got to think is the actual day that you thought, did I make the right decision in starting this firm, when Eva was born? And you had, so Mike's youngest daughter, youngest child, Mike had an argument. Was it a pro bono?
It was a
argument.
Pro bono case.
So a case
was pro bono.
Case for handling pro bono. Big case, obviously incredibly important to the client. Argument in the 11th Circuit, which is always a big deal because you don't get that many oral arguments in appeals. And the night before the oral argument that morning, Mike's wife goes into labor. Eva was born at what time?
About 3 a.m.
And what time was your oral argument set for?
It was set for 8. I
8.
was ultimately generously able to make the argument later in the day.
So we had by this point in time had enough in way of resources to have a contingency plan. Okay, Mike's going to be in the hospital. We're all emailing. How are we going to make this work? Someone's going to call the clerk's office and see if we can get a continuance of the argument. I think you ended up calling the clerk's office from the hospital.
That's
and
right.
They said, sure, we'll move you to last on the calendar as opposed to first.
That's right. And so I left the hospital at about 9 o'clock. So it was about 6 hours after Eva's birth. Thankfully, my in-laws had come and changed my clothes in the parking lot.
I brought your
went
shoes
straight
to the courthouse.
That's right.
Yeah.
James had to bring my shoes because I had either boots or tennis shoes on, and made the argument with no sleep on the day of my daughter's birth.
There's an incredible. There was a podcast made about this case, and part of that podcast has the audio from the bench, and there's this recording of Judge Beverly Martin leaning over to whoever was next to her on the bench when you walked into the courtroom, saying, "I can't believe he's here." Now, it's an incredible story because it really illustrates Mike's dedication to his clients. It's also a terrible story because it illustrates the oppressiveness of this industry that we live in sometimes, right? Because that's ridiculous that this day, the birth of his child, he had to show up in court. But you do it because it's our ethical obligation. It was absolutely the right thing to do. But one thing that we've tried to do as a firm is bring some humanity to the way that we practice. Our job is stressful enough that we do not need to add more stress to what it's like to be a lawyer in high stakes litigation. And I think that's probably the best thing that Mike and I have accomplished is bringing together a group of people who genuinely enjoy practicing together and minimizing the number of times we have to show up in court on the day of the birth of a child.
That's an incredible story. I've never heard that one. So thanks for sharing that. So you sort of, what you brought up there, I want to touch on. So you guys bet on yourself. You went out there. You've got 18 attorneys now, probably all federal clerkships, very credentialed, blah, blah, blah. It's probably fairly easy to get people to join your firm now, I would imagine. It's not a hard sell. Hey, come join our firm. Yes, I want to go to your firm. But the early days, it's probably something else. There's one thing for you to bet on yourselves, but lawyers as a class are generally risk averse. So how do you convince these highly credentialed former federal law clerks that are at big firms, hey, come join us. We don't have many cases. Trust us. We're going places. Join us. How did you do that? How did you find your people? How did you convince them? How did you recruit them? And was it challenging, or did it just, were they drinking the Kool-Aid?
James's good looks and my loose tongue. It's a good question. I mean, we were lucky to have some of the folks who joined us early, like Brandon Waddell, our now partner, kind of make the same bet on us and himself that, we made. And, it's one of these things where it's a combination of like James said, opportunity or opportunism and relationships and, being candid and honest with folks but also excited about the possibility of what one can achieve together or what a great team can achieve together. And so I think Brandon had been clerking for Judge Beverly Martin, and I had
Judge Kravitch, actually.
Oh,
yeah,
that's right. That's right. But he had gotten to know Judge Martin and had worked with her for some time. And Judge Martin recommended that we have lunch. He was coming off of his clerkship. I think he was thinking about going to D.C. to take a job at the U.S. Trademark Office. And it initially started as, a temporary role because we were preparing for trial in a commercial real estate litigation matter, and we needed some help to get ready for trial. And we persuaded Brandon to come on board and work with us. And that was thanks in part to Judge Martin's recommendation and her, very positive, I think, assessment of our firm. And ultimately, we really enjoyed working together. We did some great things together, and it doesn't hurt that he fell in love with his now wife, who, was living in Atlanta and decided not to go to D.C. Like I said, opportunity isn't always, what you create, but sort of your timing and your luck, and decided to stick with us. And, that is probably a similar story for the other folks, particularly in the early days that we hired. We talked to them about our firm. I think the excitement that we brought to our practice was something that, really resonated with folks. Like James said, we work really hard, but we really like what we do, and we really care about doing our work at a level of excellence that, makes us highly competitive within the market, but we also know how to prioritize our lives where, it's not just about how great of a lawyer you are, it's also about how good of a person you are. And, and we've always prioritized things like family and, personal lives and respected those pursuits of others and encouraged them. And that's been a firm part of our principles from day one. Being a small firm, we're able to, have really solid relationships with the people that we work with, and but also respect the boundaries and respect the fact that, most of the people we work with have families like we do, and we all desire to be with our families when we can. But when it's time to make a sacrifice and, stand up for a client and work a night or a weekend, we do, but only if that's necessary, not as a means of, just firm culture. We try to avoid false emergencies. And, that to me is a big deal. I think that a lot of firms, for whatever reason, management style or just individual organizational style, you hear a lot about false emergencies. And if you can get things done a little bit early, you can plan, prepare, think ahead, and avoid the last minute stress, the self-created stress, you really can achieve a much happier daily work life. And look, litigation practice is challenging and stressful as it is, and the external pressures of litigation practice provide a sufficient amount of stress that it really is incumbent upon us as, leaders of our firm, but also just as the, folks that work with other lawyers, to do our best to avoid creating, additional stress or pressure that could be avoided if you just plan right, or you think ahead, or you organize yourself in
I'm going to flip your
way.
question a little bit. You said at the beginning it's probably really easy to get people to come work for your firm, and I don't know if that's true, but the hard thing is finding the right people, because there are folks out there who have the kinds of resumes that we are interested in, but really the personality fit. The thing that I loved the most about Ropes and Gray too, but primarily Rogers and Hardin, was I always felt like these folks are practicing at the absolute highest level, handling the most significant cases for their clients, but they have not lost their humanity in doing so. And I want that to be the description of our firm, 20 years from now. And we've worked really hard to maintain our firm's humanity. And a big piece of that is getting people who care not just about doing work at the level we expect, but also treating people the right way. being fundamentally kind. We're aggressive litigators. We fight like hell in court, but we're not disrespectful. We're not unethical. We're not unprofessional. We pride ourselves on being the opposite. And for some reason, and I don't know why, I mean, you can speculate, but it's worked. And at our 10-year anniversary a couple of years ago, we went back and like, okay, here's all the statistics about the number of clients we've served, the number, the amount of money we've recovered for our clients, the amount of liabilities we've avoided. But the most important or the most significant one to me, and this is still true today, probably going to jinx it by saying it out loud. Since we started the firm, we have never lost a lawyer to another law firm. We've lost 2 lawyers. One left us to become a federal judge. And okay, good. I'm very proud of that. And the other left us to go work in-house with one of our clients, right? And everybody else who's come to us has stayed with us. And this is a really hard job. And I feel like that's probably the thing that I'm most proud of with the firm that we've created. And I think a lot of that credit goes to Mike, and the credit for not, maybe I've withheld my tendencies to drive people away, but I've tried to contribute to that too. I think that's, yeah.
That is a great stat, I'll call it. Although the longer you practice.
I know. I'm fixing myself. It's inevitable.
So you're coming up on your 12th year anniversary. When is that? Is it
February?
So we're almost there.
Yeah.
Just timestamp. We're in September. So a few months away. Again, you guys, grown to a very strong firm. I mean, you started strong, but you're really strong. As you look back, is there anything that sort of has surprised you along the way on this journey you guys been on? I mean, you bet on yourself, gut feel, you did it. You had a vision. It sounds like you've achieved a good piece of it. I'm sure it was not a straight line. It never is. But any surprises along the way other than the 11th Circuit argument you had to do?
One surprise, I guess, from a business perspective, when we formed the firm, there was a lot of talk about the demise of the hourly rate. That was about 12 years ago. There was articles about how a lot of firms were, doing alternative fee arrangements, and we began our firm with a similar mentality. We wanted to present alternatives to the hourly rate, and we have. I mean, we've incorporated those to some extent. But one thing that has surprised me is how sticky that has been, and that today, I think more than even 10 years ago, that is probably the most common fee structure that exists in major business litigation matters. That's a business surprise. I mean, I would have thought that our industry would have innovated more along those lines. In terms of forming the firm, I mean, obviously what we talked about, I think that although we had grand ambitions for, our practice, we did not, I don't think, ever fully visualize the idea that we would be an 18-lawyer firm within, 11 or 12 years. And so it's been, the growth has been surprising and obviously extremely positive because we've gotten to, hire all these amazing people and then become partners with, some of the lawyers that we've had the opportunity to work with the longest. And, the one thing that's been wonderfully surprising has been, how rewarding it has been to grow our partnership. We're now a partnership of 8 lawyers, and we are going to, probably continue to grow our partnership as, the years go by. And making that transition has been really rewarding and been something that, I guess in the early days, I didn't think as much about how important and how meaningful it would be to, to have partners beyond, James, who are incredibly important to our practice.
Yeah. Something that, this is going to sound odd, how difficult it is to make yourself dispensable in the law practice, right? Like and we all like to talk about or think about how we are indispensable to our clients, but this is a team-based industry, at least for the kinds of cases we handle. There are very few cases where I am the only lawyer on the matter. And the importance of being dispensable and kind of building a structure and processes that allow for that allow for people to step in and out if there's a health issue, if somebody wants to retire, if someone wants to take an extended vacation because we've had to work so hard over the course of the last year, that those are really important to people's overall happiness with the industry that we're in and the career that they've chosen. But it's incredibly difficult to do because our business is so relationship based. And that was a surprise to me, I think primarily because, like Mike said 20 minutes ago, before starting this firm, I hadn't really originated much in the way of business. And so had not been the primary client contact on my cases, or if I was, it was, I was contact with a large in-house legal department where the relationships were not necessarily as important. But I think that's an incredibly important part of building a firm that can survive past 35 years, or your rule against perpetuities on the life cycle of a firm, is making any individual lawyer dispensable so that if somebody decides they want to move on, the firm is going to survive past that. And that's incredibly difficult to do.
So, James, you mentioned a minute ago something you're very proud of the firm, and that no lawyer has left to go to another law firm. And so that's awesome. I want to ask, is there anything else as you look back that you're particularly proud of the firm, whether it's some pro bono case that you handled or something else? Is there anything else as you look back that stands out as something like we did something really cool there, whether it's for somebody else or even just for the firm or somebody in the firm?
Well, yeah, I mean, the pro bono work that we've done over the years has been really impactful, and that's, that is something that we envisioned that we would do when we formed the firm, and we were inspired by the lawyers that we had worked with who also did tremendous pro bono work. Just in the last year, I mean, our firm has been involved in some of the most significant pro bono matters, in my view, that are happening in Georgia, where we were counsel to the Federal Defender Program in a case involving the cessation of executions in Georgia during and after COVID. And, we were also the firm that stood up and challenged the 12-week abortion ban in Georgia and succeeded at the trial level. And that case continues after the Georgia Supreme Court, reversed the initial decision-making of the trial judge. So we have, those are two examples. We've also, represented individuals and I think had a pretty outsized impact in our community for the size that we are. We've also taken on some cases that were not pro bono cases, but were successful plaintiff side class action cases that we achieved some significant results in. It's a case against a prison telecommunications company that was implementing a policy where essentially after you made a prepaid deposit of a certain amount of money to receive phone calls from somebody in a jail or a prison, the company would essentially deactivate the account and take any money that was in the account after 90 days. We challenged that policy and ultimately made a significant recovery on behalf of a nationwide class of people who were damaged by that, and that was pretty meaningful. So, I mean, we've done work, both pro bono work and, what I'd call for-profit work that still makes us pretty proud of, the results that we've achieved.
Yeah. I'm going to go back to our people. Like Mike said, it started with 2 partners. We've now got 8. Of those 8 partners, 7 of them started with the firm. It's 2 of us plus 5 others who we've promoted. We've brought in 1 lateral partner. And with 18 lawyers and that many partners, when you get everyone together, there's a lot of people who are very significantly impacted by the business that the firm has built. And that's incredibly gratifying to see that kind of day-to-day impact on our folks' lives.
All right, last question. So, again, we've talked about all the stuff you guys have done over the last 12 years. As you look to the future, what's the vision? What do you guys see? And it may be for the firm, it may be something else, and it may be the same or it may be different. So, Mike, we'll start with you.
Well, it's kind of like when we started the firm. I wanted to be careful about not having too many very specific expectations, right? The idea was always and remains today that with the right set of principles and the right group of people, we can do really great things. And that continues to this day. And what I would measure our future success by is the same. Are we living by our key principles that, bring us to work every day, that cause us to be the, to provide excellent work to our clients, to, be professional in our dealings with others, including opposing counsel, and to, thrive in our community and really treat the art of advocacy, with the kind of seriousness and quality that we bring to it. And, are we attracting talented people that, in some ways have more impressive credentials than James and I have and our partners have. And I hope that we're doing that in 20 to 30 years. Will we be, another 18 lawyers? Will we be 36 lawyers in another 10 years? I don't know. And, I imagine that we will continue.
All right, James, vision for the future, whether it be for the firm or personally.
So vision for the future of the firm, to me, is to continue on the path that we're on now. Keep finding the right people, keep looking for opportunities and taking them when they present themselves, and keep working to improve the team and having a significant impact on our clients' businesses and on their lives. Personal, I hope that I never work anywhere else. This is what I want to do till the end of my career. And, as long as I can ride this out, I absolutely will.
Personally, you're going to be touring with playing guitar and a...
Gotta have some fun, too.
Our partner retreats are pretty guitar heavy.
Yeah,
that's right. Yeah. Speaking of, we have one tomorrow, and guitars are mandatory. I hope you know that.
Of course they are. Yeah.
Well, guys, Mike, James, thanks for coming. I'm glad we could do this. Thanks for joining me for the 100th episode.
Congratulations.
And congrats on everything you guys have done with your firm. I mean, it truly is impressive. And I've told you this before, and I'm not trying to buddy up or anything, but I hear from others that you guys are sort of a model that other young and up-and-coming sort of business leaders aspire to be. So great job. So for anybody out there that wants to get in touch with you, discuss whatever, maybe they got a big case in Georgia that they want to get you guys involved in, what's the best way to find you?
Well, I can be reached. My email address is mcaplan@caplancobb.com. We're on the internet, and or we have a website. You can find us on the web at www.caplancobb.com. And before I move on, I want to say this, Jonathan. It's an honor that you invited us on this podcast for your 100th podcast, and we have benefited from your advice over the years, and we appreciate that quite a lot. You've been, a mentor and counselor to us, and we've been co-counsel and opposing counsel, and I deeply appreciate our relationship. And I think it's amazing that you've built this podcast and you're celebrating your 100th episode, in addition to starting your own firm and being very successful at that as well.
Here. I'll also say I greatly prefer to be in a counselor role with you or a co-counselor role with you than an opposing counsel role. We won't talk about that.
We can't talk about this. We can't talk about this.
But I'll echo everything Mike said. Thank you so much for having us. This podcast has turned into something big, and I feel like it's a great honor for us to have been the guests on the 100th episode, so thank you.
And how do they find you, James? What's your
Same place, caplancobb.com. You can get all of our contact information, see all the amazing people we've hired, and find us there.
Awesome. Thanks, guys.
Thank you.
It's been fun.
Appreciate it.
Thanks for listening to this episode of the Founding Partner Podcast. Be sure to subscribe on Apple Podcasts, Spotify, or wherever you get your podcasts to stay up to date on the latest episodes. You can also connect with Jonathan on LinkedIn and check out the show notes with links to resources mentioned throughout our discussion by visiting www.lawfirmgc.com. We'll see you next time for more origin stories and insights from successful law firm founders.